Hello there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families, and welcome to our YouTube channel. Today I want to talk to you about non-judicial settlement agreements. So some trusts are irrevocable as soon as they're created, which means that in general, the trust maker or the person who created the trust and put their assets in it cannot terminate or modify it and take back the money or the property that hold it. You may wonder why anyone would want an irrevocable trust, but irrevocable trusts can provide some very important benefits, particularly asset protection, tax minimization, and maintaining eligibility for government benefits. In contrast, trust makers may amend or revoke a revocable living trust at any time prior to their death, but at their death, the trust then becomes irrevocable. Now, although irrevocable trusts generally cannot be changed, many states' law allow interested parties to modify a trust in certain circumstances using a binding non-judicial settlement agreement, assuming that there's no language in the trust document prohibiting their use or providing another way for the trustee and the beneficiaries to consent to the modifications. Now, in the absence of a statute permitting a non-judicial settlement agreement, the interested parties under state law, which may include the grantor, the trustee, or the current or future beneficiaries or their representatives, would have to petition a court to modify the trust or interpret unclear provisions. In states where non-judicial settlement agreements are permitted, their use can avoid the cost, delays, and lack of privacy associated with judicial proceedings. Now, a judicial settlement agreement is only valid if it does not violate a material purpose of the trust or terminate the trust in an impermissible manner, and any modification would have been approved by a court if the parties had petitioned the court. Although there are variations in each state statute governing non-judicial settlements, there are several situations in which a non-judicial settlement agreement is typically allowed, including the interpretation of the terms of the trust document if they were to be unclear, the approval of trustee's report or accounting, authorization or prohibition of a certain action by the trustee, appointment or resignation of a trustee or determination of the trustee's compensation, transfer of the location where the trust is administered, and determination of the liability of the trustee for actions related to the trust. Now, many state statutes also broadly allow a judicial settlement to address any matter that a court otherwise would resolve. A non-judicial settlement must be signed by all interested persons to be valid. If you are the beneficiary or trustee of a trust with provisions that are confusing or incomplete, or if circumstances have changed since the trust document was drafted, that makes its application difficult or impossible, a non-judicial settlement agreement may be able to resolve those issues. So speak with your local estate planning attorney if you have a question about non-judicial agreements. I'm sure they would be happy to help you, or work with the estate planning attorney you're currently working with. So I hope this helped you understand that if you have an irrevocable trust, you may still be able to make changes to it through a non-judicial agreement. So thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, and please like and subscribe our page in order to learn more about estate planning and the options that are available to you and how it all works.